The broadcast is now starting. All attendees are in listen-only mode.
Happy summer, everybody. Welcome to our webinar on operationalizing the new Standard Contractual Clauses, a topic that has been brought up several times over the past several weeks as companies struggle to figure out what they need to do next. I am honored to be once again joined by Faith Kasparian, a member of the Morse group. Hi, Faith.
Hi, Bob. Thank you so much for joining us today for this webinar. I'm really glad that our entities can collaborate to discuss this subject, which is so important for many U.S. businesses.
Absolutely. So the plan for today is to just do some introductions, as we've already begun. And then Faith is going to cover several topics from a legal perspective, why you need a transfer mechanism, what the clauses are all about, and some potential issues and concerns that people have brought up with us. So we very much thank you for those who submitted questions beforehand. We're going to try to get as many of them as we possibly can. I was just going to say, if you have any questions during the session, please feel free to put them in the questions box. When I'm talking, Faith will feed them over to me, and when she's talking, I will feed them over to her. We'll cover as many as we possibly can, but if there are ones that we just can't get to, we will follow up after this session. We already do have a first question. Will you be sharing this deck after the presentation? Absolutely. We will be providing a link to this to the slides immediately after. Thanks for asking that. So just a quick overview about who we are. I'm Bob Siegel. I'm president and founder of Privacy Ref. I have several certifications from the IAPP and am recognized as a fellow of information privacy by that organization. I am also, in addition to being the president of Privacy Ref, I am also a member of the IAPP training faculty, and I've trained thus far over 8,000 privacy professionals, many of which have told me they've gotten certified, so I'm pretty excited about that. What Privacy Rep does is provide consulting services. We try to help our clients improve their privacy program by implementing policies, procedures, and bringing technology to bear where it's appropriate to make sure the organization's privacy programs are in alignment with organizational goals as well as operational goals. With that, I will turn this over to Faith. She'll talk about herself and Morse and then talk to you about the legal side.
Hi, my name is Faith Kasparian, and Bob actually was the person who taught my privacy training class before I received the CIPP certification, so I'm indebted to Bob for that. I lead our privacy team here at Morse. We are a full-service law firm, and our goal is to provide value to our clients. I personally view myself as a creative and pragmatic problem solver, and I like to try to help clients find a practical solution to their legal problems. In particular, I love working with small to medium enterprise in the privacy space. That's very challenging because there is this panoply of laws that apply, and you really do have to figure out where is your most significant risk and address that. My practice focuses on privacy compliance with the alphabet soup of various state, federal, and international privacy laws. I also work with GDPR and international data transfer mechanisms, which is the subject of our program today. I negotiate commercial agreements that involve privacy and data security. I work on the development of privacy policies, information management best practices. I advise on incident and breach response. And then I also work on risk allocation in the privacy and data protection area in the context of mergers and acquisitions and investment transactions. Privacy and data protection have become a significant issue in all of those types of corporate transactions as the laws in this space continue to proliferate. I'm just delighted to be talking about this subject today and to have Bob join the program. I hope that you'll find it useful and look forward to getting on with the discussion. All right, so we're going to start with why do we even care about a data transfer mechanism? So for entities that are subject to the GDPR, Article 46(1) specifies that to legally transfer data to a jurisdiction that's outside the EU, that the EU does not view as adequate for protecting the data in accordance with EU standards, there need to be appropriate safeguards in place to guarantee the individual, the data subject, certain rights and remedies. So that's why we talk about data transfer mechanism at all. It's to try to provide the data with a minimum adequate level of protection that the data would receive if it would be in the EU. The EU-U.S. Privacy Shield, and prior to that, the Safe Harbor program, served this function for many U.S. businesses. U.S. businesses would certify that they would treat the data a certain way, and they would certify this to the U.S. Department of Commerce. But the Privacy Shield was invalidated in the Schrems II decision last summer. So following the demise of the EU-U.S. Privacy Shield, many companies chose to rely on a set of standard contractual provisions that would govern data transfers. These are called the Standard Contractual Clauses. The clauses that were used predated the GDPR by many years. Therefore, because the continued viability of these clauses themselves were called into question by Schrems II, that decision last summer, but also to align the old standard clauses to the GDPR, the European Commission recently released new clauses governing data transfers. As of now, I think it's very unlikely, and the regulators in Europe have said it's unlikely, that a new agreement between the EU and the US that would replace the Privacy Shield will be reached anytime soon. These standard contractual clauses will be of continued importance to US businesses to serve as a data transfer mechanism. So we have new clauses now, and the purposes for these new clauses, as articulated by the European Commission, was to bring the transfers in line with the GDPR, and also to allow some flexibility through what they call a modular approach, which we'll discuss that in a little bit, and also by letting more than two parties enter into the clauses. And finally, another purpose was to include provisions that were meant to address that Schrems II decision. And ultimately, that Schrems II decision hinges on some particular issues in our US surveillance laws, which allow access to data. And Schrems II, that finding that perhaps that, or definitely, that particular access is not in line with EU standards. So now we have new clauses. They provide a new set of transfer mechanism for transfers from processor to processor and processor to controller. This is new. Under the old clauses, there were only controller to processor and controller to controller clauses. Now we have four different modules: controller to controller, controller to processor, processor to processor, and then this processor to controller. So there are more types of clauses. They were all set forth in one decision from the European Commission, and then in order to use them, the lawyer or whoever is working with the clauses will need to pull out the particular provisions that are relevant to the context at issue. So you would go through this the European Commission's decision and pull out all of the controller to controller provisions, put them in one document. All the controller to processor provisions, put those in a different document. Another interesting feature about the new clauses is with respect to transfers from a controller to a processor or a processor to a processor, the new clauses purport to include all of the required Article 28 provisions under the GDPR. So Article 28 requires that if data is shared with a processor, and perhaps it's useful just to explain, a processor is an entity that handles data solely to provide services or solely on behalf of the controller. And a controller is the entity that determines purposes and means of processing of the data. So the entity that gets to decide what happens with the data. So when there is sharing between a controller and a processor, Article 28 of the GDPR requires that there be a contract in place and that the contract includes certain specified provisions. These provisions govern how long the data can be retained, what the data can be used for. There are basically a laundry list of contractual provisions. Now, these new standard contractual clauses will include those provisions. So essentially, that will, I think, eliminate the need in many circumstances for a data processing agreement when there is a data transfer that's associated with the context. Previously, you often saw the Article 28 provisions in the main body of the DPA, and then attached would be the old standard contractual clauses. They'll all be in one document now because these new standard contractual clauses include the Article 28 provisions.
Right. So Faith, we do have a question here. Given that many of our listeners have DPAs already in place with the existing standard contractual clauses, is there anything you would recommend about how to incorporate the new standard contractual clauses with those DPAs?
So we have some dates that are relevant in that respect. So if you have an existing agreement in place that was entered into or that will have been entered into prior to September 27th, 2021, and that contract or DPA relies on the old EU standard contractual clauses, those agreements may continue as they are until December 27, 2022. So there's essentially an 18-month grace period to amend all previously executed contracts. But the proviso there is that the processing under that old contract remains unchanged, and that there's some assessment as to whether reliance on the old standard contractual clauses ensures appropriate safeguards. So bottom line answer, if you have an existing agreement with the old clauses, as long as there hasn't been a change to the processing and reliance on the old clauses continues to ensure appropriate safeguards, those agreements may stay in place until December 27, 2022. My sense is that the most efficient path at that point would be just to move to the new standard contractual clauses that are appropriate for that relationship. I could imagine that perhaps there would be certain contractual provisions that may have been agreed to that maybe provided additional safeguards. And in that kind of context, whoever is working with those contracts would need to really assess, well, how could you perhaps incorporate the new clauses as an additional addendum with some kind of provision specifying that the clauses would control in the event of any conflict to ensure the protection of the data.
Okay.
For new contracts, though, the new standard contractual clauses must be in use as of September 27, 2021. So if you're entering into new contracts, starting September 27, 2021, you're going to have those new standard contractual clauses attached.
Yep. Just as a follow-up, somebody is, you use a phrase, processing remains unchanged, or provided processing remains unchanged. This individual is looking for some clarification on what that means.
Well, we could research a little bit and kind of look into EU guidance, but my sense would be processing is such a broad term. covering basically anything that can be done with the data. My sense is if you would change the scope of what is done with the data, that would maybe constitute a change in the processing. As an example might be if previously the data was hosted by the controller and the processor just accessed it but didn't host it. If the operations changed such that the processor would now be hosting, I think that would definitely be a change in the processing operations. Another just example off the top of my head, if the processor is handling only or holding only encrypted data, but perhaps then it would change to be pseudonymized data or in data kind of completely in the clear, not pseudonymized at all. I think that would be a change in processing operations. So not necessarily a bright line answer. We could look to guidance from the European regulators, but my sense is any kind of ministerial change would probably constitute a change that might require the new standard contractual clauses.
Okay, we have a couple of other questions here, if you don't mind. Do the new clauses with the Article 28 items incorporated include indemnification provisions?
So indemnification is not something that is directly included in the clauses, but it's absolutely something that would be typically included in the risk allocation among the parties.
Okay, and similar along those lines, do you have a viewpoint or insight regarding liability caps and indemnities relative to Clause 12 of the new standard contractual clauses? It seems unclear to this particular participant.
Yeah, I mean, I think that liability caps are absolutely something that is heavily negotiated between the parties, and I think that the type of data that is handled will bear on what's a reasonable liability cap. But at the end of the day, the importer is still responsible for their actions. And, you know, I think it will be interesting to see whether, and certainly responsible to the data subject. So any liability to a data subject would not be able to be capped vis-a-vis the importer and the data subject.
Makes sense. Excellent. Thank you. Let's move ahead.
So one point of ambiguity with respect to the new standard contractual clauses, and this was something that was noted by the European Data Protection Board when they reviewed the draft clauses that were put forth in late 2020, and that is whether the new clauses can be used by a data importer if the processing by that data importer is directly regulated by the GDPR. So a context kind of to just put it in place there is, let's say you have a controller that is not established in the EU, they're in the United States, but they're directly regulated by the GDPR because of offering goods and services to data subjects or monitoring behavior. Can the new standard contractual clauses be used as a data transfer mechanism if the processing by that importer is directly regulated by the GDPR? Recital 7 is where this ambiguity sort of comes forth. And the implementing decision states that these new clauses may be used only to the extent that the processing by the importer does not fall within the scope of the GDPR. So this language absolutely suggests that the new clauses may not be used if the importing company's processing of the data is directly subject to the GDPR. And this was something that the European Data Protection Board had recommended that the European Commission clarify. There really was not clarification on this point. And I think it puts importers that are directly subject to the GDPR in a very difficult position, because if that directly regulated importer can't rely on the standard clauses, it's very unclear whether an alternative data transfer mechanism would be needed and what that would be. It could be that there is an interpretation of the GDPR that a company that does fall, whose processing as an importer falls within the scope of GDPR, has appropriate safeguards in place if the importer is GDPR compliant. It could be, and that would absolutely have a huge impact on the number of standard contractual clauses that are required. Worth noting, though, that it would certainly not lessen the requirements of Article 28. So you'd still need to have those Article 28 provisions in place with the importer. And incidentally, at the same time that the European Commission released these new standard contractual clauses for data transfer, they also released standard clauses that include all the provisions needed by Article 28, just a standalone kind of Article 28 set of clauses. And another point is that even if the new standard contractual clauses aren't required, it would not lessen the requirements to identify appropriate supplementary measures for protecting the data in certain jurisdictions such as the U.S. And that is a piece that Bob will be diving into toward the middle part of the program today. So that ambiguity is unfortunate. I have been hoping that the European regulators would issue some guidance on this point. You know, companies can consider entering into the new clauses as a precautionary measure, but I think there are some potential drawbacks to that. Just as an example, if the new clauses don't cover transfers where the processing is directly subject to the GDPR, then some sort of other data transfer mechanism would still be required, and the new clauses wouldn't be doing that. My bottom line here is that if the EU regulators don't issue clarifying guidance before September 27, then the safest course might be to use the new EU clauses with some type of incorporation statement specifying that they apply only to the extent required by the GDPR or only to the extent required by applicable law. Ultimately, for the very short time being, though, the old EU standard contractual clauses may be used for new contracts until September 27. Unless there are any other questions on this particular point right now, I'd like to mention a few things about Brexit and the UK, because that adds another layer of complexity, which is the new EU standard contractual clauses have not been recognized as an adequate data transfer mechanism by the UK Data Protection Officer, the ICO, the Information Commissioner's Office. So the only clauses that the ICO currently recognizes as an adequate data transfer mechanism are the old EU standard contractual clauses. The ICO has put forth a very slightly adapted version of the old EU standard contractual clauses on their website, just to align references that are currently to the GDPR or to the EEA to the UK or to the UK version of the GDPR that was enacted in connection with Brexit. So it's really either use the old clauses or this slightly adapted version of the old clauses that the ICO has put forth, which makes things a little bit complicated. So you're in a position where for an importer, that processes both UK and EU personal data, or for an exporter that's sharing both UK and EU personal data, and where the businesses want to use the standard contractual clauses, ultimately 2 sets of clauses must be used in that case. The old EU standard contractual clauses, or that slightly adapted version that the UK ICO has put forth, that will govern the UK data, and then the new EU standard contractual clauses for EU data. The ICO has indicated that it intends to publish UK standard contractual clauses at some point during 2021. I think it would be wonderful if they simply signed on to the new EU standard contractual clauses so we could get by with 1 set attached to an agreement, but we'll wait to see if that happens. So one of the key features of the new EU standard contractual clauses are certain provisions that are inspired or that are reflective of the Schrems II decision, and that will require certain types of supplementary measures and assessments of the transfer to ensure that there will be appropriate protection in the jurisdiction where the data is going. And Bob is going to talk a little bit about what those supplementary measures look like, and that's just a key feature of operationalizing these new standard contractual clauses. So I'll hand the mic over to Bob.
Not so quick. Of course, there are a couple of other questions that have come in. One is, if you could just take a moment to explain the extent to which the clauses can be tailored or customized to different industries or sectoral areas. That was one of the questions that were asked, and there's one more following that.
So it will certainly be fine to supplement the clauses with provisions that may be specific to the particular relationship, but parties may not deviate or revise or amend the clauses. If the clauses are amended in any way, then they no longer serve as the data transfer mechanism.
Okay. And the other question is, we see a lot of other countries with emerging laws. China just came out with theirs, or just approved theirs. We have Brazil recently. Do you foresee additional transfer mechanisms, additional sets of clauses having to be required for each of these different jurisdictions?
I think that's absolutely possible. And I'll actually quote something that I think Bob has really wished for, where I'm wishing for guidance in the short term from EU regulators about whether the clauses apply to processing that is already subject to the GDPR. Bob wishes for a global privacy standard that's adopted by the world so that we can agree on key standards that protect data. But until Bob's wish comes true, I think we may be stuck with continued variety and overlapping sets of laws that govern data, and that could mean different contractual provisions regarding data transfer or other types of handling of data.
Huh. I don't know if I was wishing for that or just aspiring to it. I'm not sure which it is. But thanks for giving me credit for that, I guess. So let's talk about the other part that Faith alluded to, and that is accountability. How do you take these things from Schrems II and make them applicable within standard contractual clauses? Now, when we talk about accountability, we're talking primarily about accountability of the exporter. Now, the exporter may be a controller, it may be a processor, but they're the ones that are going to initiate the transfer. And they're going to be held responsible to make sure that the information is protected properly. Now, the importer has some responsibilities as well, certainly to properly protect the information, but also the question is, or the ability here would be for them to provide information back to the exporter about what's happening. And in fact, that's part of the supplementary measures that we'll be talking about as we go through this. Within this document that the recommendations that I've provided the citation to here, is a accountability roadmap. And there are 6 steps to make sure your standing contractual clauses are effective, and how to make sure that they can be used. Now, one other thing to note before we really get into this, and I think Faith implied it, but I think it's worth mentioning directly, is the issue is not only between the EU and the United States. It has to do with any country that could potentially surveil personal information in a non-proportional manner for a democratic society. Now, that may go well beyond the United States. It may go beyond FISA Section 702 and other laws here in the U.S. as well. So let's take a look at each of these steps in turn. The first step is to know what your transfers are. So, and I know that sounds, very grandiose, and yes, we all do that already, but chances are you may not have everything. You need to understand what kind of personal information is actually being transferred. Where's the data going to be stored? Is it stored back in the EU and you're just referencing the data from outside of the EU? Or are you actually transferring the data to another country, third country? Where is it going? And by an extension of that, not only who the importer is, but are there any onward data transfers, any sub-processors that are involved potentially? And who that importer and those sub-processors are. Now, one tool that's already provided in Article 30 of GDPR for this is the Records of Processing report. You should have within that Records of Processing report all the exports of all the data that you're doing, or at least the classes of data that you're doing. But there are things that you want to do beyond just having that report in place. You really want to review whether you actually need to do that transfer. In the old days when I was still writing code, if somebody asked us for data to do some processing on our behalf, we would just send them everything, right? We didn't minimize it by any stretch of the imagination. Data minimization has become more the standard and more the practice today. But do you still need to really transfer all that data? Does somebody need personally identifiable information in order to do the processing that you're asking them to do, for example? It's really a time-consuming exercise, it's a complex exercise to track all of this down. But is it really necessary to dive so deep that you need to understand what data element and what table is transferred through what mechanism to each of your importers? Or is it simply enough to know what class of data subjects you're transferring? Again, getting back to the Article 30 type of report that we were talking about earlier. But also remember where the data is going in the cloud. Are your cloud providers in the EU, or are they forcing you to do a data transfer because your cloud instances are elsewhere? Also keep in mind that rendering data in a third country that is stored in the EU is a data transfer. That's something that a lot of operational people don't understand and make the statement, no, we're not transferring the data, we're just rendering it. It's still a data transfer. And the other thing I suggest you look at is what the IT standard procedures and emergency procedures are that may result in a transfer. For example, we worked with one client where they did all their backups in the EU to one particular country. So it stayed within the EU, but unfortunately the servers in that country broke down. So instead of transferring it to another set of servers, the backups to another set of servers in the EU, they started sending it to the data center in the US. It's an emergency situation. It was the fastest thing they could do, but it resulted in a data export. So we had to cleanse all of that data and move it to another location in the EU. There is a question that came in. Going back to what can be changed in the clauses, is it possible to add an addendum to the new clauses?
Well, I think it would all depend on what the addendum specifies. So if the addendum doesn't deviate from the clauses, but simply supplements or perhaps provides protections that are greater than the protections specified in the clauses, then I would think that would be acceptable. I think with respect to any supplement, I would always want a provision clarifying that in the event of a conflict, the clauses control. But
Yep.
Just want to be clear that you can't actually deviate from what's in the clauses. You can just supplement.
Okay, great. There was another question for me here. I keep mentioning rendering data. Rendering data is the display of data in another country. So if I have customer transactional records that are stored in the EU, but in the Philippines, I have a customer service organization that references that data stored in the EU and displays it in the Philippines, that is a data export. Okay, it's that display which is rendering. Okay. Thank you all, by the way, for all the questions. You guys have been great so far. You then want to figure out what your transfer tool is. We've been talking specifically about standard contractual clauses, but the question is that really the best path to go? Have you considered binding corporate rules or ad hoc contractual clauses? By the way, those two have the same concerns as standard contractual clauses for potential surveillance by governments. So you would have to put in some sort of mechanism to actually go and protect that data that the government could potentially surveil. There are codes of conduct and certification mechanisms which are currently in the process of being defined. But again, you want to make sure the data is appropriately protected. There's also adequacy decisions. I don't want to belittle them at all. If a country is considered adequate, you don't have to use any of those other mechanisms to protect the data. You can just freely transfer it between those jurisdictions in the EU. And then there are derogations. The derogations are something that's brought up fairly frequently, that if you can't use some of those protection mechanisms, you can always use derogations. But derogations are in place specifically for one-off situations, not for regular transfer of data. So the example I like to use is we have a French citizen who's come here to Florida, goes to visit Disney World, and unfortunately is in a car accident. They're taken to a hospital. It would be impossible to set up any kind of standard contractual clauses or binding corporate rules or anything like that for the medical staff in Florida to talk to the medical staff in France to get that person's health records. So that's a derogation. It's a one-off transfer of information. In this case, a derogation is the vital interest of the data subject. But even the derogations, such as contractual necessity, are still for one-off situations, not for regular transfers. So be cautious when you use those kinds of things. Once you identify the tool, including standard contractual clauses, you need to look at the tool's effectiveness. Particularly, is the data that's being transferred going to have the same protections or similar protections in the receiving country that it has in the EEA? Now, some of this is under the importer's control, right? If I have rules in place for access control or access to production data for my employees, that's clearly under the importer's control. But there are the laws that, like FISA, Section 702, that allow the government to do surveillance as well, that is not under the control of the importer. So you want to look to see if there are laws that may impact the protections that are being provided. If there are, that's a red flag. You're going to have to do something to try to protect the data from that surveillance being done. Are there practices that your importer has that may impact the protections? We've seen in our practice, we've seen situations where the organization didn't understand privacy really well, so their practices definitely thwarted some of the protections that should have been in place. So word to the wise there, make sure your importers actually know what they're talking about. And you have to look at not only the recipient, the importer of the data, but you absolutely need to look at any onward data transfers as well. The things that you want to consider, number one is a data subject's ability to exercise their rights, the right to access, the right to rectification, the right to transfer transfer the data, the right to be forgotten. All those rights need to be exercisable by the data subject. If they aren't, then the tool is not effective for the data transfer, not providing the same types of protections. And you want to look at what laws that the importer has to comply with to disclose that personal information to their government. Now, if the law is allowing for the supplying of that data in a proportionate manner, in a necessary and proportionate manner, as described by the EU Charter of Fundamental Rights, that's okay. But if it goes beyond that, you have a problem. We've got to figure out a way how to get around it. You want to consider the purpose of the transfer, what types of data and are being done, what roles and types of data importers you're using. You want to look at the industry sector. Some of the industry sectors that you're transferring data on behalf of are protected, like to an attorney, like to a medical health provider. Is the data going to be stored or accessed remotely? Most importantly, is the data in plain text, pseudonymized, or encrypted? We'll talk more about that in a couple of slides. And again, the onward transfers. There's also a reference to the European Data Protection Board's European Essential Guarantees. These are legal requirements to make the limitations to data protection and privacy rights recognized by the Charter of Fundamental Human Rights that can be summarized by 4 essential guarantees that the EDPB requires. First, that processing should be based on clear, precise, and accessible rules. I would extend that to say that you want to make sure that those rules are covered in your privacy notice from a transparency standpoint as well. That the necessity and proportionality with regard to the legitimate objectives pursued need to be demonstrated. Not only that you state that they're there, but actually demonstrate that there is necessity of processing and proportionality of processing. That there be an independent oversight mechanism of this processing. So it could be the supervisory board. In fact, the guarantees talk about the judicial arm of the EU government providing that oversight. And there need to be effective remedies available to the individual if they think something has been done improperly with their data. Okay, let's just take a look. If the tool is effective and the data is properly protected as per what the EU expects, you begin your transfers. The important part, though, and this was brought up early on in this discussion by Helen Dixon, the Irish Data Protection Commissioner, you don't just sign off the standard contractual clauses and throw them in a drawer. You need to reevaluate them periodically to make sure they're still effective. If the tool is not effective, in this case, the standard contractual clauses, you need to put supplementary measures in place before the transfers can begin. Otherwise, you may be subject to actions being taken by the supervisory authorities. And again, you want to reevaluate periodically because technology may change, practices may change, and it may make your tool effective that way as well. When it comes to supplementary measures, they can be either contractual, technical, or organizational. Just to be explicit about it, you're establishing controls to prevent local authorities from accessing personal data in a non-EU compliant manner. You are, for lack of a better phrase, you're looking to thwart government access. Okay. You may look at contractual and organizational measures, as you'll see in just a moment, but from my perspective, my evaluation, generally speaking, they may not be sufficient on their own. You may also need to implement some technical measures too. Again, points of consideration. What format is the data in? Is it plain text, pseudonymized, or encrypted? what categories of data are being transferred. Is it sensitive information or is it standard personal information, if you will? How complex is the processing being done? And finally, what are the onward transfers that you need to look at? So if we look at some sample supplementary measures, from a technical standpoint, you should look at encryption in transit and at rest. In transit is going to prevent government from watching data that's in transit. If it turns out that the measures to protect the data by using secure FTP, for example, are insufficient, you may want to incorporate the data down at the application level, encrypt the data down at the application level to prevent that access. And also you want to have the data protected at rest as well. So think about a cloud provider that is providing backup capabilities. You can store the data at rest in an encrypted manner, and that way they would not be able to get any government access as well. Okay, data stored or transmitted in plain text is risky. It's something you should consider not doing. So this puts into jeopardy, if you will, the ability of a data importer being able to look at the data themselves and process the data. One way to address that is pseudonymization. Do you need to actually send the personal information, the identifying information of the data subject as part of the data going to the importer? Or can they do their processing and just reference the token that identifies that, and they always send the token back to the exporter for processing? If you send pseudonymized data and the importer doesn't have access to the identifying data represented by that token, it's not personal information to them. You have to be careful to make sure that other aspects of the data that are transferred, other characteristics, don't uniquely identify an individual, but it's one way that you can do that transfer. Another way is through split or multi-party processing, where multiple importers are doing processing independently of each other, and neither have enough information to identify what the purpose of the processing is, nor the identifying information for a particular individual. And when their independent processing is done, the results are sent back to the exporter, they combine it, and then they complete the processing for whatever the purposes were. Okay. Now, there are also contractual measures. The obvious one is to require some technical measures. We see that in the data processing agreements today. We also see that in standard contractual clauses today. There are some transparency obligations. One, if there is a request by a local authority to see the data, to communicate that to the exporter before you fulfill it. Similarly, there's something referred to as a warrant canary. The way this works is that on a frequent basis, maybe it's daily, an email goes out from an importer to the exporter saying, we have not received any access requests. And that if they do receive an access request, but email doesn't go out that day, the canary stops chirping. So that's another way to take a look at it. You want to include audit rights. That's something we recommend all the time. There should be audit rights in the DPAs, and the Article 28 requirements should be carried forward into the standard contractual clauses as well. The importer should also be required to notify the exporter if there's been a change in the law. The importer would be keeping close watch on the laws that apply to them. So if they see something that may have an impact on the accessibility of the data by the local government, they should notify the exporter. And of course, there's data subject empowerment, making sure data subjects can have all of their rights fulfilled, including notification that they could bring in supervisory authorities if they have to. From an organizational standpoint, have policies in place. How can you access your data? Who can access your data? How you collect data, and so on. You want to document any access requests that you may have received and how you've responded to them, and if you've responded to them. You may want to publish transparency reports. You see this frequently from Google and Yahoo and Bing and Microsoft. They've received X number of requests from the government, and they've fulfilled Y number of those. Always keep in mind data minimization, something we talked about our clients in lots of different perspectives, to make sure they only collect the data that they need and no more. Aside from the fact that it will keep government surveillance down a little bit, you can't lose what you don't have. So it has a positive impact on data breaches. And also you want to make sure that the technical measures are properly done. Access controls, training of employees, logging of access to personal data, things of that nature. Okay. So if you go through all of this process and you and the importer and the exporter agree that the measures are effective, begin your transfers. But again, go about and reevaluate them periodically. Things may change. If it turns out the measures cannot be declared effective, the importer can't meet its obligations due to laws or its practices. So the exporter needs to decide to transfer the data or not. And if they do decide to transfer the data, they need to notify supervisory authorities. The supervisory authorities may take some action. They may suspend or prohibit the transfers if the data can't be protected properly, or they may impose fines. And as you know, those fines can be very expensive. As far as procedural steps, you need to fill in the blanks of the standard contractual clauses. You want to make sure that you've identified all the supplementary measures in those standard contractual clauses. But as Faith pointed out earlier, if the clauses are modified or measures are added that contradict the clauses, they are no longer standard contractual clauses. They become ad hoc contractual clauses. And those need to be reviewed by the supervisory authorities before you can start transferring the data. Okay. And finally, I know I've said this before, you need to reevaluate periodically your entire mechanism for data transfers, all your tools that you're using, all of the supplementary measures you're taking. It is a life cycle. You know, if you're signing up for accepting transfers or doing transfers, it is an ongoing process. You're going to need resources dedicated to keeping this process in line. Now, a few questions that came in while I was talking. If your risk-based analysis determines that it's unlikely your data would ever be affected by government laws like 702, then would supplementary measures even be needed? My opinion, Faith and I have been talking about this quite a bit over the past few days, and I think to some extent we differ on this. My belief is that if the risk analysis shows that you would not be affected and you can document that, you may not need supplementary measures. Faith, take it away.
Yeah, as I read the European Data Protection Board's guidance on these measures, it just feels to me that this really ought to be something that is decided between the two sovereigns. And I think we're putting corporate America in a very difficult position in terms of trying to comply. I think we're essentially telling corporations, we're encouraging them to thwart efforts by law enforcement to access data in a way that is technically lawful in the United States. And the way I read certain of these requirements on supplementary measures is if you have a processor that must access data in the clear in the United States, then I think based on the broad scope of FISA 702 and how that applies to certain entities, and I think given the broad reach of that Executive Order 12333, which was at issue in the Schrems decision, I don't know that you can truly ultimately say that the data can't be accessed. But you know, I think it's really going to be a case-by-case analysis. The European Data Protection Board guidance certainly does allow for the subjective experience of the importer in terms of whether they have received these types of access requests from government authorities to be a factor that's considered. Also, that can be a factor is whether other businesses in the same type of industry have received these types of requests. So, you know, I think that there's a reasonable basis for saying that the data won't be accessed, but ultimately, I would love for there to be some alignment between the sovereigns and take the businesses out of the equation.
Yep. We've got several other questions here. Hopefully we'll be able to get to all of them in the next couple. We won't be able to get to all of them in the next couple of minutes. So we'll follow up with those who asked that we didn't get to. One of them is applies to, I think, everyone listening is, are there requirements for processors to send to their subcontractors a specific assessment questionnaire to ensure risk compliance? What are your thoughts there?
So Bob, I think you're welcome to take that. It aligns to some of the points you've already been discussing on the guidance, or I'm happy to share my thoughts on it.
So from my perspective, you know, you need to ensure that your sub-processors are providing the same level of protection that you would be providing yourself. Whether those protections are being guaranteed to your data subjects through your privacy notice or through contracts to the people you're doing processing on behalf of. Now, how you do that, whether it be through a questionnaire or a series of investigations, I suggest is up to your organization. We tend to recommend to our clients to actually do a PIA type of operation with any prospective new processor, and then follow it up with lots of questions. As far as it being a requirement to send a questionnaire, I haven't seen that specific item in place. Have you, Faith?
No, but I would think if you wanted to use a questionnaire approach, you just look to that EDPB guidance in terms of assessing whether there are points in the law that would allow for access, and you'd ask very pointed questions to the sub-processor about their history of receiving subpoenas, whether they view themselves as within scope of these various laws. You'd want to ask a number of questions that basically track the EDPB guidance on that point. I did want to circle back to one of the questions that arose earlier on liability under Clause 12 of the new Standard Contractual Clauses and the indemnification point. So the term indemnification is not used, but absolutely each party is liable to the other, and it's for any damages caused by breach of the clauses. And we know in the opening of the clauses there's a clarifying conflict point that if there is a conflict, then the clauses will prevail. My sense is that it may be trying to put a cap on a party's liability under these clauses may be a conflict and might not be enforceable. I think capping liability in other parts of the commercial relationships are, fair game, and parties could try to put a cap in place, but I think there's a good basis for thinking that it won't be enforceable. Yeah, Bob, I did have one final kind of question that occurs to me as we're just dealing with all of these assessments that you're talking about, and that a lot of work is going to be required by the businesses. So how does a small organization do this in a cost-effective manner? And do you have any sense of what resources are reasonable to allocate toward data protection and privacy compliance? Could there be anything based on head count of the business or revenue?
Yeah, it depends. I mean, I hate to use that old chestnut, but it depends on the type of processing that's being done, the expertise within the organization. Bear in mind that even a data protection officer, as identified under GDPR, or a privacy office, as we normally think about it, does not have to be internal. It could be an external organization. We serve as data protection officers for a number of companies, for example. And sometimes it's more cost effective to outsource it. But if there's a specific situation, because some of these questions that we did receive, as you recall, were very specific, that somebody would like some guidance on, they can absolutely get in touch with either of us by following up with our organizations here. So I guess I kind of sidestepped that question. There's no clear answer. We spend a lot of time trying to figure out the right size of an organization and for data protection and where it belongs in an organization and all of that. There is one other question I just want to quickly touch on, and that we didn't talk about it much, and that's multinational corporations. Are there other things that have to be done or considered for multinational corporations? I'll let you take that, and then we can wrap things up.
Sure. So certainly you have with affiliated entities the option of binding corporate rules, but that's going to be a very lengthy process, going to require regulatory supervisory authority approval. But the standard contractual clauses absolutely can be put in place among affiliated entities. And even before the new clauses were released, we often would work on putting the associated clauses in place as attachments to an inter-affiliate data sharing agreement. So that's absolutely a path that affiliated entities can take. But as Bob had noted, you're still going to need to analyze various importing entities that are affiliated. What's their access? How are they handling the data? So that you can ensure appropriate supplementary measures. And also you'll need to analyze the data flows so you can make sure that entities sign on to the appropriate modules of the clauses.
Okay, thanks, Faith. It's once again been a pleasure doing this webinar with you and working up with you and your team to everything built up to this. Hopefully in the next several months, we'll operationalize something else for our audience. Thank you all.
Thank you so much, Bob.
Okay, thank you all for participating today. You will be getting a copy of these slides as well as some important links. A link to the the recommendations from the European Data Protection Board, as well as a link to the IAPP's breakdown of the standard contractual clauses by module. So hopefully that will help you in your endeavors. Have a great afternoon. Speak to you all soon, hopefully.
Thank you. Bye-bye.